All right, so good morning. Did you have time to read what I gave you a couple of weeks ago? Pena? Did you find time to read the document on law of contract? Christopher? Patience?
No.
Miss Smile? But the whole idea of me giving you readings in advance is for you to read, yeah? So that you come to class prepared. Isn't that what we agreed? Isn't that what we agreed? Didn't I say that if you read in advance, it will also make your understanding easy in class and you also contribute significantly? Isn't that so? Didn't I indicate that the idea of a class is for you to learn so that you become good graduates who can apply the knowledge in practice? Did I say that? Linda, where are you? Did I say that? Are you too busy for school? You can't read? You need to prepare. You need to come to class prepared, yeah? You remember I said you are students and your preoccupation is studying, isn't it? Yeah, so if you come to class prepared, the understanding will be easier than if you just wait for me to explain. Okay? So, simple question. Apart from the course outline and the précis on the law of contract, what else did I send you? Louder? Yes? Mm-hmm. Mm-hmm. Good. Did you read it? Did you read it? Okay. All right. So, what do we understand by law of contract or contract law? Is it different if we say law of contract or contract law? Jean? When we say contract law or law of contract, are we talking about the same thing or they're different issues? Louder so that your friends at the back are able to understand.
We're talking about the same thing.
Excellent. So what is a contract? Okay, first let's discuss what the law of contract entails, or contract law. So the point is that law of contract and contract law is one and the same thing, right? So what do you understand by law of contract or contract law? It is a subject or a branch of civil law. By civil law we mean private law. By private law we mean the law that governs the relationships between two or more individuals. So contract law is a law that governs contracts or legally binding agreements. So you see that as individuals, you come across contract law almost in each and every situation or each and every aspect of life. For example, you are students, you apply for admission to be at the University of Lilongwe, right?
Yes.
And then the University of Lilongwe offered you a place, right?
Yes.
And then for you to cement that relationship, what did you do? You accepted the place, right? Now, by cementing it, you had to pay school fees, isn't it? So that means you have entered into a law of contract or a contract with the university. Now, what is the nature of the contract? For you to get education, right? What happens if the university is not giving education? It is breaching the contract. Now, the university is supposed to give you education. What are you supposed to learn? What are you supposed to give in return? I need hands up, yeah? Mona? Where is Mona? Yes, Mona. You are the first to come to class, yeah? So what are you supposed to give in return? Second? Learning in the first place. We teach, you learn, right? So if we teach and you don't learn, what are you doing? You're breaching the contract, isn't it? Are we together? So those are the terms of the contract. Any questions so far? What's the difference between law of contract and contract law? Patience. Niger? One and the same thing, yeah? Patience? What's the difference between contract law and law of contract? Louder? Edwin?
It's the same.
One and the same thing, right? Good. So what is that? What is a contract? You remember we defined a contract in our first class, right?
Yes.
What is a contract? Yes, Linda?
A contract is an agreement between two or more people which creates legal relation between them.
Awesome. Excellent. If you answer like that in an exam room, if it's out of 10, I'll give you 10 out of 10. The only challenge is the use of the word people. You need to insert party instead of people. Because you can have a contract between a company and a company, right? Between Castel and Chibuku. They can enter into a contract. So they are not people, right? They are parties. Yes. So excellent. May you please repeat, or can somebody repeat the definition that has been given by Linda? Lorraine? Yeah, it's okay, but now I'll give you 5 because it's a contract. Yes, it's an agreement. But she made a very good statement at the end. Yes? What's your name? Judith, yes.
Is the agreement between two or more parties
Linda, you want to repeat? Please listen carefully.
Let me come again.
Uh-huh.
Is the agreement between two or more parties which creates relationship.
Yes. It doesn't stop there. Linda, just repeat so that your friends are able to understand.
A contract is an agreement between two or more parties which creates legal relations between them.
Legal relations which are binding and can be enforced or enforceable by law. Patience, what's a contract? Edwin, what's a contract?
Is the agreement between two or more parties which creates a legal relationship.
That is binding and can be enforced by law. Ivy, what's a contract?
Is the agreement between two or more parties which creates legal relationship between them.
Good. Innocent? What is innocent? Yes, what's a contract?
Is an agreement between two or more parties which creates a legal relationship between them that is binding and enforced by the law.
Good. Patience, what's a contract? Are you paying attention? But everybody was able to explain, and it's only you who is not able to explain. What's your name? Patrick. Patrick, you keep on confusing me. That's a problem of wearing caps and this other day not wearing cap. You play soccer, right?
Yes, sir.
Which position?
Midfielder.
Okay, so what is a contract?
It's an agreement between two or more parties which creates a relation in which are binding and can be enforced by the law.
Excellent. Taku, what's a contract?
Contract is an agreement between two or more parties which creates legal relationship, a relation which are binding and can be enforced by law.
Excellent. Patience, what's a contract? Can you tell me something about a contract? At least you must have heard something. Okay, so I think we almost all of us are able to understand what a contract is, isn't it? Jane, what is a contract?
A contract is an agreement between two or more parties
Mm-hmm.
that is enforced by law,
Mm-hmm.
legally binding,
Mhm.
enforced by law.
Good. So obviously, I mean, I've emphasized on this, meaning this is going to be an exam question, right? So I expect all of you to pass, at least the majority of you to pass, because it's straightforward. What is a contract in paper?
This is a legal agreement between two or more parties
Mm-hmm.
that include. This is a legal agreement between two parties
Mm-hmm.
that creates a legal relationship and can be binding and just.
Good. So, Christopher, what's the difference between an agreement and a contract?
Agreement and the contract they are different because you can just agree.
Uh-huh.
While a contract
Uh-huh.
involves enforcement of the law.
Mm-hmm. Okay. Yes, Linda?
An agreement is an expression of willingness.
Mm-hmm.
While a contract is an agreement between two or more parties which creates legal relationship.
Mm-hmm. Excellent. So in simple terms, the difference between an agreement and a contract is that in a contract, the intention is that it should not be legally binding. Whereas in a contract, it is legally binding. Clear? Can you give me an example of an agreement and then an example of a contract? Miss Mwala, an example of any agreement. So if I send you to say, can you buy me a bottle of Fanta? If you agree, is that an agreement, Miss Mwala? It is an agreement, right? Is that a contract? Excellent. So, can you give me an example of a contract? What's your name? Eh? Gertrude. Yes, Gertrude Chilambe. Yes. So, what is? Can you give me an example of a contract?
Okay, if one offers you
Mm-hmm.
to buy his own car and you agree
Mm-hmm.
and you
Okay, so if I employ you in my law firm, you are a lawyer, I'm employing you in my law firm and we sign a contract. That means we have entered into a contract of employment, isn't it? So you sign a document. Okay, we said that a contract can be oral, but it can also be written. But most of the contracts, serious contracts, are supposed to be in writing, right? For the reasons that I'll give you. Right, so we have,
Sir,
yes?
I have read about sales agreement.
Mm-hmm.
What happens to it?
So a sale agreement.
Yeah.
Sale agreement is a type of a contract, but for sale. So already I've talked about contract of employment. I've already talked about contract of, we're now talking about contract of sale. Yeah, there are several types of contracts. which we'll discuss in due course. Yeah, so you have a contract for provision of services, you have contract for shipment, contract for transportation, contract for carriage of goods, so many kinds of contract for provision of academic services. Yeah. So a sale agreement, if the parties intend that it should be legally binding, then it will be a contract. Yeah. Noel is Noel around. Noel, you're also Patrick. Midfielder.
Yes, sir.
Position?
10. Attacking
10 is not midfielder. Is it?
Attacking mid.
I thought 10 is a striker.
No.
It's a midfielder.
Beyond striker.
So Messi is a midfielder.
This is behind. Yeah, it's midfield.
Okay, so we have several laws that govern contracts. In Malawi, we have a Sale of Goods Act, which we'll discuss in due course. But generally, in Malawi, contracts are governed by what we call common law or judge-made law. You remember the first class? We talked about common law. Law that was inherited by Malawi from the United Kingdom, being a colonial master. And it is essentially in what we call judge-made laws or case law. And case law, the key is the principle of precedent, also known as Gertrude, Stereothesis. You know, these are the issues that I will ask in an exam, yeah? So if you don't pay attention, don't expect to pass the exam. I want to ask you something that we haven't learned in class and something that we haven't emphasized. So we're talking about judge-made laws. So contracts, that's why I gave you those contracts, rather cases. That's judge-made law. That's principles of common law. If you read the Mahata case, for example, you see that Judge Maungulu was referring to cases from the United Kingdom. So that's common law. Are we together? Ngulue, are we together? Yakosa? Yeah? Oh, yes. Yes, that's the answer, right? Okay. So the point I'm trying to make is that in other jurisdictions other than Malawi, say for example in the United Kingdom, there is a legislation that governs contracts. Kenya also has I think it's called contract. Is it? Yeah. Basically, it's a statute governing contracts. But in Malawi, we don't specifically have a statute apart from, you know, the pieces of legislation like the Sale of Goods Act, Employment Act. It has relations or it has connotations relating to contracts. But the key law governing contracts in Malawi is case law or common law or judge-made laws. What do you understand by the principle of stereothesis? Niger, is it Niger or Niger? Niger. Is that a Scottish name? Irish?
No,
English. You know the difference between English and Scottish and Welsh? Yeah, okay. So what's the principle? What does the principle of stereothesis entail? Mona, can you sit properly like in class? Hey, the gentleman in the hood, what's your name? Precious. What's so the challenge with you putting a hood, next time you don't wear a hood, I wouldn't recognize you like our friend Patrick. No, it is confusing me. But it's fine, I mean, it's fine. Only that it gives me a problem to recognize you. So what's the difference between, what does the principle of stereothesis entail? What is the meaning of the principle of stereothesis? Before Linda takes it. Linda knows, yeah? Who is the friend sitting next to you? Is that Ivy? Yes, Ivy. What's the principal diadesis?
The judgment that if the principal, that other judge is closed.
Yeah, to an extent. Yes. So it's a precedent, right? Now, the key is judges lower than you would follow precedent, but judges at the same level, they are not obliged to follow precedent. They can only be guided by precedent, but they don't have to follow it. Very important point that I've just made. Clear? So, okay, you are supposed to follow what I say, yeah? Because the assumption is that I know what I'm talking about, right? But you don't necessarily have to follow what Jean is saying. Clear? Because she's also a student, she's also learning. You get a point? That's a principle precedent. I am also supposed to follow what people who are more experienced and knowledgeable than me say. So that's how principle precedent works. You listen to a coach, right? You may listen to captain, maybe, because he's senior to you. Your fellow midfielder, maybe not. Maybe he's jealous, you know. You wouldn't want to, yeah, so that's how principle of precedent works. Are you trying to understand what I'm trying to say? Taku? Okay, good. So, what are the key elements of a contract? You remember we talked about formation of a contract? The key elements of a contract? Precious. Key elements of a contract. What is an offer? You remember the first lesson? Yeah?
Yes.
Well, precious, yes. You remember the first lesson? You were not around, you were, yeah? Okay, elements of a contract. Let's start with the elements of a contract. Mr. Sisha. Offer. Yes? Niger. You gotta catch up. Please catch up. If you miss a class, please catch up. Otherwise you think that I'm punishing you when I want you to be up to speed. Yeah? Jane? Offer has already been said. Yes, Patrick. Acceptance. Okay? Patience. Taku.
Consent.
Yes, consent. Yes. Tulinde. Louder? Louder? Not maturity really, but we say competence, right? You need to have competence. Yeah, legal competence. Yeah, Mona? Consideration. Excellent. What else? Offer, acceptance, consideration. What else? We talked about competence. What else? Gertrude? Legality. Well done. Linda, what else?
Well, the consent should be genuine consent.
Should be what? Genuine consent, yes. Innocent, what else?
At least now say
Consideration,
consideration.
okay, good. What else? Mutuality. You remember mutuality? Mutuality, you need both to agree. You can't compel somebody, right? Mutuality. Good. So now let's break down these elements. Very important. Who understands what an offer is? An offer must be made in a contract, right? Somebody has to offer and somebody has to accept. So give me an example of an offer. Give me an example of an offer. Judith. Where is Judith? Yes, Judith. Yeah, give me an example of an offer. Offer. Work what? Example. Louder. Money. An example of an offer. Simple. This should be very simple, right? How? Good. So if I offer you a job to say, I want you to work for me, that is an offer, isn't it? Clear? Somebody has to make an offer. So that is an offer. If I'm offering you a lift, it is an offer, right? But it's not an offer for a contract, isn't it? Yeah. So that's an offer. If I offer to buy you lunch, that's an offer, isn't it? But now we're talking about offer in relation to a contract. So I need to make an offer to give you something. Are we able to understand that? So an offer must be made. Every contract must contain a clear and detailed offer that explains the central transaction. The offer must explain the central transaction. What are we going to do? Why are you offering? And what am I accepting? So for example, offer for exchange of goods, offer for services, offer for so many other issues. A contractor. What would a contractor, or is it a constructor? A contractor offering you to build a house, that's an offer, right? Good. An example of, what is an example of an acceptance? So one of the elements of a contract is an offer. We've just defined an offer, right? The second one is acceptance. What is an acceptance? What is an acceptance? Yakosa, give me an example of an acceptance. Louder. So you have not accepted it. Yeah. So you're giving me an example of non-acceptance. But I want an example of acceptance. Taku? Example of acceptance?
It's the same idea where if you offer me a job and I agree to take upon your acceptance.
Yeah, so that's acceptance, right? So acceptance is expression of agreement to the other party with regards to the offer that has been presented. Can you start with an acceptance before an offer? Yeah? So the acceptance must mirror the offer terms. Otherwise, if it does not offer the mirror terms, then that is a counter offer or a rejection. So if I say, for example, I'm offering you employment, and you are saying, no, I don't want employment, I want partnership. Everybody here should understand partnership, right? Who discussed partnership the other day? Isn't that you, Ivor? Who discussed partnership act? Is that you, Gertrude? Last Friday, who discussed the partnership act? No one? It is you, Yakosa. Yeah? Do you still remember what he said? Do you? You don't remember? Okay, so if somebody is offering you employment and you're saying, no, I don't want employment, but I want partnership, is that an acceptance? Mona? It is not, right? What is it? It is a counter offer or a rejection of the offer. Clear? Now, what is consideration? So all parties to a contract, I'm not saying people, right? I'm using the word party. All parties to a contract must provide the other party something of value which entices the other party to enter into the agreement. So consideration is a key. For a contract, offer acceptance easier, but you need now consideration. You need to do something of value to cement the relationship. Let me just give you a crude example. You are university students, so you should be able to tolerate this example. If you have asked a guy, whether a girl or a boy, you've asked a girl or a boy to be in a relationship, what would signify that you are in a relationship? Niger, you seem to be that kind of guy, eh?
The actions.
Louder?
The actions.
The what?
The actions that the girls take.
What sort of actions? Okay, in a wedding, all of us might have attended a wedding in church. Let's talk about a church. What cements the marriage? Louder, you gotta raise your hand and speak. So a vow is an agreement, offer and acceptance. But what is it that cements? Yes, Mpenya? You're not married. Don't tell me you're married. Yeah? Huh? So that's just an evidence. Where the priest is saying you may kiss the bride. Isn't that, that consideration that now have that? Isn't that?
Yes, sir.
Yeah? Yeah?
Yes.
Jean, isn't that how it works?
It works like that.
So if a boyfriend, sorry, I want you to understand consideration, right? Let's assume a guy asks you out and you've accepted and he wants to kiss you and you're refusing. Is there consideration in a relationship? Would the guy really say that I'm in a relationship?
No.
Yeah. So you see the importance of consideration, right? Something of value. Clear? Excellent. I hope we are able to understand. Patience, are you able to follow?
Yeah.
Good. So something of value is referred to as consideration. And it does not necessarily need to be money. It doesn't have to be money. It should be something of value. So if you want to enter into a contract for, okay, so if you want offer and acceptance of employment, I offer you employment, you accept. What would be the consideration for a contract of employment? Signature. Signature, isn't that signifying acceptance? Mm-hmm. Isn't that just acceptance? Yes, Mpenya?
Going to work.
Going to work, yeah? Yeah, and actually doing the work. Doing the work, that's consideration. Yeah. Something of value. And if he's paying you, that means now there is a contract. The contract has been cemented. Yeah, but signature can also signify, but signature is basically an act of consideration. Because you can have offer, acceptance, and the terms of contract. And then you sign that now we're entering into a contract by signing. So it's an expression that you want, it's an intention that you want that to be a legally binding document. So I'm giving an example here that, for example, Chikondi agrees to give Chimwemwe a bicycle in exchange for cleaning services in our home. A party promised something of value in exchange for specified action or inaction. So consideration here will be defined as the value that motivates the parties to enter into a contract. So the value that motivates a party to enter into a contract, and it distinguishes the contract agreement from a gift. Unlike promises made in a contract, failing to follow through on a promise made with a gift is not enforceable by law because it is not considered a breach of contract. Consideration can take the form of effort or money expenditures or a promise to perform a service, a reliance on a promise, or an agreement not to perform an action. So that's consideration. You need to discern that, okay, what is of value here? What is it that is enticing that particular person to get into an agreement? So that is the consideration. Are we following? Are we following, Taku?
Yes, sir.
Let's assume you've been offered by Caps United to play for them, and you accept. What would be the consideration?
You showing up for training.
Say again?
You showing up for training.
Yeah. So that means you've already entered into the contract, but then for there to be binding, for the agreement to be binding. So a consideration can be something you're gonna be promised for in future. Yeah. So the consideration would be the payment of money. That would be the consideration. Yeah. That you play and then we're gonna pay you. So that promise would be promise for a consideration to seal the contract. Yes.
Can terms and conditions be the consideration?
Say again.
Can one consider?
Sit properly and pose the question properly.
Can someone consider terms and conditions of the work?
Consideration. No, those are generally terms and conditions of the contract. Yeah. But a consideration can also be factored in the terms and conditions. That's why it's important to read the terms and conditions. It's important to read to see what the contract, what are the parties really agree. Yeah. So I am saying I want you to, okay. So another example would be what an easier one. Sale of car, offer acceptance. What would be the consideration? To give you the car, right? Consideration, you have the car, but you haven't paid. So the consideration for the buyer is that he's getting the car. The consideration for the seller is that you give him the money. Meeting of the minds, then you have a contract. What I regard as consideration may not be consideration to you. Easy, huh? Okay, so I get into a contract with the university to deliver or to supply paper or stationery. The university is expecting me to give them stationery. I'm expecting to get payment from the university. Consideration is me delivering. Consideration for the university is receiving stationery. My consideration is then paying me something of value. Clear? Eh? I think now it's becoming clear, right? Today, are you in the mood of Patrick or Noah? Noah or Patrick? It's interchangeable, isn't it? Yes, Mona.
In the terms and agreeing before accepting.
Say again?
Can the terms and conditions be before accepting?
Nah.
Like you offer something,
Mm-hmm.
so there are terms. Like
Mm-hmm.
if you have to buy this car, there's 1 year guarantee. So someone has to accept it.
Very good question. So, first you need to have an offer, and then you need to accept. Now, for you to make it legally binding, you need now to agree. So the offer is for a particular service, right? Then you also need to accept that particular service or goods, right? Now, how do we govern the delivery of the goods? How do we govern the payment for the goods? So those are now the terms and conditions of the contract. Clear? So I'm offering to deliver a lecture in business law. Offer. You accept to be my students. Acceptance. Now, how do I deliver and how do you learn? I want you to be disciplined in class. I want you not to eat in class. I want you to raise hands before you respond. So those are the terms and conditions of our contract. Clear, right?
Yes.
Taku? Clear? Okay. So there are two theories regarding consideration. So there is what we call benefit detriment theory and what we call bargain theory of consideration. So benefits of the promiser is a burden on the other. For example, if a gift promises are not enforceable because the promiser might gain personal satisfaction from the act, so there is no sufficient detriment to constitute adequate consideration. You remember I said my burden to the university is to get paid, to deliver. My burden. The benefit from the university is to receive the papers. Yeah, so that's the benefit. That's my burden. And in terms of bargaining theory, yes? Okay, so benefit detriment is the benefit that the one who promises receives, the one who offers receives. So the benefit. So a gift, for example, if I'm giving you a gift of football boots, soccer boots, it's just an offer, it's just a gift, right? I don't expect to benefit anything. So it cannot be benefit because I'm just giving you. My satisfaction is that I've given to somebody who is in need. My teaching here is not for free. I expect to get paid. So I'm not doing this gratuitously. Yeah, so there is a benefit. Clear? If you give a tithe in church, that cannot be consideration, yeah? Because the reward is in heaven, isn't it? Yeah. So you cannot say consideration. You cannot say, no, Pastor, because of your sermon today is not satisfactory, I'm getting back my tithe. There is no contract. So that's benefit. You need to have something that you benefit for it to be consideration. Consideration, you need to benefit something. Yeah? That's why it's something of value. So that's the first theory. The second theory is that of bargain. So it talks about if you make a promise in return of something. If you make a promise in return of something. The condition is that the person making the promise was given something in exchange for making something of value. So if you read what I sent you, I'm saying the difference between the bargain for exchange theory and the detriment benefit theory is the party's motive for making the agreement. So what are you benefiting? What are you losing? You need to have something. It basically defines the value of the consideration. So then there is maybe I shouldn't go that deep, but we talk about sufficiency of consideration and adequacy of consideration. Is the consideration of value enough to constitute something that is that can entice somebody to get into a contract? So yeah, so in short, consideration, it should be something of value that entices the offer to get into a contract, and also the one who is accepting to get into that contract. You talked about terms and conditions of the contract. Those are just what governs now that relationship. Are we together this far? That's why I want you to read in advance so that you're able to grasp. But I'm pretty certain now you're able to see the picture. Miss Maya, are you able to see the picture? Would you define what a consideration is? Something of value that cements a contract. Something of value that would entice the offeror to accept a contract, and the one who is accepting to also accept the offer. Yes, Pena.
So, I want to ask that the bargain theory,
Mm-hmm.
we use it as the way politicians do it, the bargain theory.
Okay, so the question is, do we enter into a contract with politicians? Legally speaking, yes, we do. We call it social contract. But I don't want to confuse you, because this is now a concept in public law. So public law, social contract is that you vote a politician into power on the basis of the promises that is made. So if he is not able to fulfill those promises, then there is that breach of trust. You can have a vote of no confidence. He has breached your trust. So we call it social contract. Does that answer your question? Good.
So,
Yes. Get organized and then pose the question.
okay. In our documents, there is written this. I declare this.
Mhm.
What does that entail?
Mm-hmm. Okay, so in other documents you see that I declare. It's just it's basically an oath or affirmation. You are declaring that whatever you're saying is true. So that is an affirmation or an oath. So it's really not a contract, but you're just explaining that whatever you have said is true. So it's like you are swearing that this is true to the best of your knowledge. But good point. Does that answer your question?
I was asking if that we can do in what contract.
You're taking oath of office. Say, for example, if the president is sworn into office, he swears, that you abide by the Constitution, that he will lead. So he's taking an oath of office. To an extent, you can also say that he's entering into a contract with the people of Malawi. So that's a social contract. But we're not talking about social contracts at the moment. We're talking about contracts in the sense of agreements, legally binding agreements. So competence, what do we mean by competence? So competence, you need to be legally, you need to have legal capacity to enter into a contract, right? You need to have legal capacity to enter into a contract. Yakosa, do you have a kid sister or a kid brother? You don't? You do. How old is she or he? 10. How old are you? 17. So do you think you can enter into a contract with your sibling who is 10 years old? You can't. Why? Lauda Yakosa. It's too young. Yeah, so they do not have legal capacity to enter into a contract. Yeah? Patience. Would you enter into a contract with a mad person who you find, say, in area 18?
No.
Why not?
Because she doesn't think.
Because he doesn't think, yeah, he's not mentally stable, yeah. So you need, so what this is what we mean by legal competence. You need to have competence. So you can only enter into a contract with an adult. Who is an adult in Malawi? Where do you draw the difference between an adult and a minor? This should be easy, huh? Judith, are you an adult or a minor? Can you get a driver's license? How old are you? 21. So you're an adult. But Ives, obviously. Yakosa, you said you're 17? You are a minor. Mpenya, how old are you? 18. Are you an adult or a minor? You're an adult. Okay. At what age can we legally enter into marriages here in Malawi, from what you understand? So you're happy that you can enter into a marriage? Huh? 18 and above, yeah, okay. At what point do you get a license here in Malawi? Jane, you have been so quiet. 18 and above, yeah. So at what point would one enter into a contract? Can you vote? 18 years? You can vote, yeah? Yeah, so the age of majority in Malawi, then it is 18, where you can enter into a contract, where you can have driver's license, where you can vote. You are regarded as an adult. You are regarded as having legal competence. You are no longer a minor. So the point I'm trying to make is that you need to somebody who has should have a legal capacity to enter into a contract. Now this is where it becomes interesting. Did you read the case of FAR trading against the Malawi Post Communication, Malawi MPC, Malawi Post Corporation? You did, yeah? Yeah? Who read? Yeah, Penya read. Who else? Linda, you read? Are you able to explain the facts?
I can try.
Yeah, go ahead.
Well, it was an agreement between two people, claimant and defendant. The agreement was that claimant was
All right, no, that's fine. In the second half of the class, I'll give you time to read the cases and then we'll discuss. So the point is, you need to have competence to enter into a contract. So do you think I can have competence to enter into a contract on behalf of the university? Taku? Can I enter into an agreement on behalf of the university?
Yes.
Can I enter into an agreement on behalf of Silver Strikers?
No.
Why?
No, we're not part of
I don't have the legal capacity. I'm not part of Silver Strikers. Is the picture coming out clear? Can I, Pena, can I sign your marriage certificate? Huh?
No,
Why?
you're not legally.
I'm not related to you.
Yes.
I'm not you are Mposo. But I think I can still sign. You know, what if you marry to my son or my nephew? Okay, so you see the picture, right? You get the picture?
Yes.
You need to have legal capacity. So, Mr. Msisia, if I give you what you call power of attorney to do something for me, that means I'm giving you mandate to sign on my behalf. But if I don't, then you're not my agent. We'll discuss agents in due course. Are we together? So you need to have legal capacity. So legal capacity can be discerned in so many ways. Then we're talking about competence, yeah? Now we're talking about legality. So if I give you Precious, yes, Precious. If I give you a contract to say, Precious, I want you to transport these drugs for me to Brazil. Yeah? Drugs, if they arrest you, that's your fault. Don't mention my name. Is that is there a legality in that contract? It is an illegal contract, yeah? You don't enter into a contract to commit a crime or to do something illegal. So a contract must represent a legal activity, not an illegal activity. So if you want to enforce that contract, the police will just arrest you to say, why did you enter into that contract in the first place? Clear? Ivy, would I, if I say, Ivy, go steal chocolate in Chipiku, because I want to give that chocolate to my girlfriend for Valentine's. So if you steal chocolate worth 100,000, I'll give you 30,000. Is that a good contract? It is not. Yeah, why? What did we agree? What are the terms and conditions of this class? In other circles where I teach, if somebody just speaks without raising their hands, I make them do push-ups. In my other life, that's what I do. So next time I'll wear my other cap, you do push-ups. Nigel, you seem to be happy with push-ups, yeah? Okay, so we're talking about what? What are we talking about? We're talking about legality, right? And now you do understand that a contract needs to represent a legal activity. What about mutuality? So all parties must agree to the contract on their own free will. You don't have to enter into a contract by showing somebody, forcing somebody. So mutuality, you need a free consent. Is that you, Gertrude, who talked about, no, it wasn't Gertrude. Laureen, you are the one who talked about free will, free consent? Yeah, so free will, free consent, mutual intent. You both need to agree. Are we together? Ever heard of the offense of rape? What is the problem with the offense of rape?
Against the will. The person is against the will.
Lack of consent. Lack of consent. I'm not talking about that is a contract now. But I'm just trying to signify the lack of consent. So there should be mutuality in a contract. Okay, good. So what are the types of, before we go to the types of contracts, what are the elements of a contract? Patience, give me 2 elements of a contract.
Offer and agreement.
1 out of 2. Offer and?
Agreement.
Yes, agreement to an extent, yes, but what is an acceptance? Good. Excellent. Patrick, you're looking at me. 3rd? Consideration. Well done, Niger. No, there are several. We talked about acceptance. There's so many. The one that talks about capacity, competence, right? What else? Gertrude? Legality. What do you mean by legality?
Open documents must represent
Legal activity. Well done. Mutuality. What do you mean by mutuality? Excellent. Elements of a contract, are you able to define them, give examples? Sounds like a good exam question, yeah? Can you write down the 5 elements of a contract and define and give examples of each? 10 marks. Is that a difficult question, Patience? Not really, huh? Just give me 5 for now to start with. Taku? Don't do that. That's a legal activity. That contract is illegal. You are showing her the answers.
Oh, no, so I wasn't trying to answer. I'm right.
Also, give me 5. 1. Repeat what you said initially. 1. 2. Yes, the one that Patrick said. It starts with a C, then an O. Then. Yes. Good. One more. You're almost there. One more. I also asked you to give an example of a mad person. What is it? What was I talking about? I even asked Patrick whether I can enter into a contract for Silver Strikers. What was it about? Competence, right? Good. Are we together? Now, what are the types of contracts? We have what you call express contracts. So express contracts will provide for specific terms of the contract. So express contracts, you have specific terms. And then you have what you call conditional contracts. So the fulfillment of a contract depends on the meeting of specific conditions. So for example, conditional contract. Mpenya, I will employ you in my law firm if you graduate. Offer, you accept, but it's conditional on graduation. Clear?
It depends upon.
Condition. So conditional contract. Express contract is straightforward contract. Yes, sir? Good morning, thanks. Okay, give us 10 o'clock.
This is 10 o'clock. Okay?
And we should just finish this.
Yeah, all right, no problem. Sure.
5 minutes? 5 minutes, sir? Is it okay, 5 minutes?
Just finish my program.
No, we also want to take a break now. And what you want to do is part of what we're discussing. Conditions of contracts. Yeah. Then we have a joint contract. A joint contract is where multiple parties are involved in a contract. So if there is a contract between myself, Precious, and Linda, that's a joint contract, right? We have a joint venture to do something. That's a joint contract. Then we have what you call implied contracts. Implied contracts are often verbal. These contracts are situational rather than explicit. So, implied contracts. So, what we just did, what we just said, Pena, it was just an example, right? But you may take it seriously. You may say, no, it was an implied contract that if I graduate, you employ me. Then you have these witnesses. No, but that was just an example. Then you say, no, you repeated it. And you even, so that would be an implied contract. Then we have what we call unconscionable contracts. These are where one party has far more power than the other one. So it's a contract where, for example, I'm employing, you ever heard of, it's an illegal contract, yes, but I think you may have heard about it, where you take people, ladies from Malawi, you take them to Dubai, and then you get their passports. So yes, it is a contract, though it is illegal, but that is an unconscionable contract because you're taking advantage of somebody who is in a less privileged position. Then you have what you call adhesion contracts. So this is a contract where one party has more leverage than the other. Unconscionable, same as adhesion. The only difference is that the other one is like oppressive. Unconscionable is oppressive. Leverage is where I have more room than what you have. Yeah. So then there is what we also call option contracts. So these are contracts that give the option of entering into a different contract at a later date. Then you have what you call fixed price contracts. So the parties agree on a set price for a project. So these are just types of contracts, but there are so many types of contracts. Employment contract, sale of goods contract, shipment contract, all those kind of contracts. Any questions this far? So let's just take a break and we'll come for another half. Then, yes, please proceed.
Are the laws that govern the contract and elements of binding the contract the same?
The laws that govern what?
The contract
Mm-hmm.
and elements that binds the contract.
Yeah, they're the same. They're the same. So I said the law of contract really, you cannot find it in a book. You can find it in a book, but in a legislation or statute. So we get all these from common law. What is common law?
Common law, the case law.
Yes, good. Or else, other name for case law? Good. Yeah, so case law, judge-made law, common law. What is the key principle in common law or judge-made law?
It follows
Precedent. What is the Latin name for precedent? Stare decisis. What is stare decisis?
this is whereby judges, or let's say the people who work in the law industry, must follow a certain
Precedent. Okay, let's just take a short break. Yeah, so the basic rules of contracts. The first is what we call privity of contract. So if Linda and I get into a contract, I offer Linda to buy her car, she accepts to buy a car, and then that means we have a contract between me and Linda, right? Is Mona going to be that part of contract? Hands up. Hands up. Yes, Miss Smile. Why not? She's not a party to the contract. The answer is she's not a party to the contract. Okay. So that's the answer. So what do you understand by the term privity of contract? Privity of contract only governs parties to the contract. The parties to the contracts are the ones who have the rights and duties under the contract. Privity of contract. Ivy, what do you understand by principle of privity of contract? So it's the exclusivity of the legal relationship. You can only have rights and duties if you are privy to the contract. If you are privy to the if you are party to the contract. Jean, what do you understand by privity of contract?
It governs the parties which are in the contract.
Mm-hmm. So a third party to the contract cannot benefit from the contract or cannot be obliged by or bound by the contract, right? Privity of contract. Are we together, patients? Privity of contract. Because I was waiting for you guys because I knew that you would want me to repeat. Even a radio would get tired, yeah? Is it? Can somebody explain a privity of contract? The principle of privity of contract. Chisomo? Well done. What does that mean?
It means that if one is not involved in the business or in the contract, does not take part in this.
Yes, he's not bound by the contract, cannot benefit or be burdened by the contract. Privity of contract. Very important term to know, yeah? Edwin, what does privity of contract mean? Good. It's two ways, yeah? Benefit from or be sued from the contract. Now, we have another principle which we call law of agency. So law of agency, you remember I asked Patrick, I was talking about silver strikers. Unless silver strikers give me the agency, unless they're saying I'm their agent, then I'll be getting into a contract on behalf of silver strikers. If I am an employee of the university and I have authority to act for and on behalf of the university, then I can bind the university. But if there is no that relationship, then I'm not going to be bound. This is what we're discussing, Linda, in the morning, the case of FAR distributors against Malawi Post Communication. That gentleman, is that Mr. Mangolenjo or something, was not an agent of the Malawi Postal Communications Corporation. Clear? Will you get into a contract on behalf of your parents? Yes and no, yeah? Yes, if you have been authorized by the parents. No, if you have not been authorized by the parents. So that's the principle of agency. You have a question?
No.
Then we have what you call variations. Yes. But you just said you didn't have a question.
No, I thought you were going to explain what the law of agency means, so you did not.
But I explained, yeah? I also gave examples.
Oh, I didn't hear you, sir.
Okay, so law of agency is where an agent is somebody who's been given authority by a principal. So if there is an agent, there will always be a principal. If there is a principal, there will always be an agent. So I was saying, can I be an agent of the university? Yes, if they've given me authorization to be an agent. Would you be an agent of your parents? Yes and no. Yes, if they've given you authority to act as an agent. No, if they haven't. You would have situations whereby you would sell a car on behalf of your parents to say, I'm selling you, this is my car. So people will say, but is it not your parents' car? Say, I have authority to sell the car. And then your parents will be saying, no, we did not authorize her to sell the car. Then that means the contract is invalid because you did not have authority. So even legal capacity, you did not have the legal capacity to enter into a contract. So with the languages, the contract is invalid or null and void. Ever heard of null and void? How do you spell null? You want to do push-ups, yeah? Yes, Penya. Good. Void, how do you spell void? Edwin?
Void. V-O-I-D-E.
No, just V-O-I-D. Okay, good. So null and void means invalid. Yeah? Clear? So variations meaning basically they mean changes in a contract. So these are variations in a contract, changes in a contract. So you have those terms and conditions. You remember, Mona, you asked about terms and conditions? Now, if you change the contracts, that means there are variations. So variations are adjustments to a contract. They need to also be mutually agreed. If you just vary the contract by yourself, that means you're changing the contract. That means there's a different kind of contract altogether. Clear? So if there is an amendment to a contract, you have to follow the same procedure. The elements have to be there. Offer, acceptance, because it's a new contract altogether, right? You are changing the contract. Clear? Nigel, are we together?
Yes, sir.
You know, when I was going to school, I did not have a cell phone at that time. I had a cell phone. I think I was one of the first guys to have a cell phone at the university, but I was not taking it to class. So it was easier. So these days it's difficult to tell whether students are on WhatsApp or they're taking notes using their cell phones. Eh? How do you use your cell phones? Are you taking notes or you are on WhatsApp? Tricky, isn't it? Tricky. Do you get into an exam room with your cell phones? You don't. All right. So the point is, variations are changes to a contract. You need to mutually also agree to variations. Ivy, can one person change terms and conditions of a contract? One party to a contract change? Louder?
No.
Why not, Chisomo?
Because it was a contract.
Louder?
Because it was a contract, which means it was agreed by two people.
Good. Well done. Well done. Well done. Yeah, so variations would be the same as amendments, but amendments are actually now corrections or additions. Yeah, variations is, for example, an example of a variation would be where I am agreeing to sell you an Avensis. You know an Avensis?
No. What's an Avensis?
A Toyota Avensis.
Oh, it's a car. Okay.
Somebody was asking me, Bwana, mugule Mira. I said, Mira? Sikuizwa Mira. There is a car called Mira, eh?
Yeah.
Is it a Nissan?
I don't follow that.
So say, but Mira, so many things can be referred to as a Mira. Yeah? So I'm not surprised that you don't know an Avensis. An Avensis is a car. Do you know a Camry? A Camry? Oh my goodness. What kind of car do you know? Do you know a Mercedes?
Yeah.
Okay, so if we enter into an agreement to sell you a Mercedes, and then I'm bringing you a BMW. Do you know a BMW? So if I give you a BMW, that means there is a variation of a contract, right?
Yeah.
Because the offer was for a Mercedes. Now I'm giving you a BMW. That means it's a new contract altogether. That's a variation. So you have to agree as well. So an amendment is, say for example, if I'm selling you a Mercedes at 4.5 million, but now because of adjustments in prices, you know, even devaluation, then the costs goes up to 5 million, that means we amend the price. So that's an amendment. Clear? Are we able to see the difference between variation and amendment? Kisomo? Variation. Variation is basically going outside the contract. You vary the terms, you're changing the contract. Changing the contract altogether. Whereas amendment is just, okay, I think to put it easier would be, I gave an example. I'm selling you a BMW, but then I'm bringing you a Mercedes. That means we have to vary the contract. You need now to agree, because your acceptance was to buy a Mercedes. Now I'm giving you a BMW. It's a different kind of contract. So that means there is a variation. Now, for that to be effected, you also need to agree. Meaning, if we agree, we need to amend the contract, to change the contract. Clear? Are you sure? Okay, good. Sometimes you'd force a variation, but if you force a variation, that means it's not mutual, right? That means you cannot accept. That means the contract has been repudiated. That's the language. Repudiation of a contract. Repudiation. That means you are breaching the contract. Repudiation. At least you should know one word today. So if a taxi driver, sometimes you jump on a minibus, and then the minibus will say, no, I'm stopping here, I'm not proceeding to Bwalo Lanjovu. That means they are repudiating the contract, because when you are getting into the minibus, the agreement was that they will take you to Old Town. So they say, no, I'm stopping by Crossroads. They are repudiating the contract. So you should tell the taxi driver, the conductor, that you are repudiating a contract. Would they understand? Show that you are educated. Show them that you are repudiating a contract. Okay. So sometimes when you enter into a contract, so I enter into a contract with Takudzwa, but now he is leaving for Zimbabwe. So he's saying, okay, I'm leaving for Zimbabwe. Now the contract will be with Niger, my fellow Zimbabwean. So enter into it. So you transfer the rights to Niger. So we are the parties, right? He's not an agent, he's not privy to the contract, but you can transfer the rights. So that we call that a innovation assignment or a transfer of contractual rights. So you can either change the parties of the contract, or you can just do an assignment. We call it an assignment. But I also need to agree to that assignment to say everything in this contract, now the payment has to be made through Niger. So that's an assignment. That's also a term you need to know. Or transfer of contractual rights. Meaning I can also sue him now, right? Because he's a new party to the agreement. He has assigned the contractual rights to him. Clear? Patience, are we following? Then we have what we call breach, termination of a contract. So termination of a contract is, what do we mean by termination of a contract? For the contract to cease, yeah? I'm terminating a contract. So I'm taking away my offer. I'm taking back my acceptance. So there are several ways of terminating a contract. If we are selling a vehicle, the moment I sell you, the moment you pay me, and you transfer ownership, that is what? That means the contract has ended, right? It's done, it's been concluded. It's water under the bridge. But if you haven't paid me, so I can also terminate a contract to say, okay, you haven't paid me, there is no contract, I'm refunding you the money, the deposit that you paid. So that's another termination of contract. Termination of contract simply means you are cutting out the legal obligations. Is that clear? Then we have what we call breach of contract. So breach of contract happens where one person, one party to the contract is unable to fulfill the terms and conditions of the contract. In which instances would we have a breach of contract? Yakosa nguluwe. In which instances would we have a breach of contract? You are making noise while I was explaining. Edwin, breach of contract? If one party to the contract is unable to fulfill the terms and conditions of the contract. So we know the terms and conditions of the contract, yeah? So if you're not able to fulfill those, then there's a breach of contract. I heard somebody coming into class saying, I want to remove all of those students who haven't paid school fees. So all of those students who have breached the terms of the contract. Linda, are you one of the guys who have breached the terms of the contract? All right, so you understand the breach? Breach is not fulfilling the obligations or the terms and conditions of the contract. Breach. You've breached the contract. You have not complied with the terms of the contract. So breaching a contract. If somebody has breached a contract, that means you terminate the contract and then you sue them for breach of contract. You've broken the promise. So there are remedies. Either you can force them to perform, what we call performance. If you read the case of Malawi Housing and Mahata, it was based on performance. So for example, yesterday, one of my clients was arrested by the police because he sold an engine to a guy from Ntaja. That engine did not meet the requirements of the guy from Ntaja. So the guy from Ntaja said, I've waited for you to give me a replacement, but now I want my refund. So my client was saying, I cannot refund you because I've already ordered an engine from Dubai and it is going to be here in 6 weeks. So the guy from Ntaja said, I've already waited for 4 months. I can't wait for 6 weeks. I need my money now. So the guy said, I don't have the money. So I said, oh, you don't have the money? You are in custody. So my client was the guy who was put in custody. He said, I'm in custody. May you please come? So I said, no, my other colleague can come. He said, no, the case is too big for your colleague. Please come yourself. I said, okay, I'm going to come. So I went to the police station. I listened to the story. I said, but look, there are several ways. You said you have an engine that you can give to this guy from Ntaja to be using while waiting for the 6 weeks, because we don't want the guy from Ntaja to lose business. He's a minibus driver. So the guy from Ntaja said, no, I don't want to use that engine because knowing this person, if anything goes wrong with that engine, he's going to sue me or he's going to give me problems. So I don't want that. All I want is my money. So I said, okay, look, you have his money and you're saying the engine will come in 6 weeks. When do you think you can pay him? Because you're saying you don't have money. So I said, in 2 weeks. I said, my friend, he's going to pay you in 2 weeks. Would you accept? He said, as long as I have my money. I said, look, 2 weeks, draw a post-dated check, get out of custody, Ntaja, case finished. So basically the guy wanted performance. Either give me the engine or refund my money. Is there a contract there? The contract was repudiated, right? Because the guy paid, but he was given a 40 engine. So performance, that's why he went into custody. Yeah. Questions on breach of contract? What's the difference between termination of a contract and breach of contract? Ivy, let's see if you're learned. Ivy. Breach. Innocent. Breach. What do you mean by breach of contract?
It's not fulfilling the obligation of the contract.
Good. Excellent. Yeah, what do you understand by termination of a contract? Laureen? What? What's the question? Louder, please.
What do I understand by termination?
Yes. Termination is cutting down the relationship, the legal relationship in the contract, yeah? It can happen if you have concluded the contract or if there is a breach of contract and then you terminate the contract and sue for what? For relief, for redress. Redress can be compensation. Redress can be performance. Performance is like asking them to perform their obligations in a contract. Okay, so when you talk about binding, what does the term binding mean? Yakosa, you're not ticking today. What's the problem? What are you thinking about? Yakosa Nguluwe, you don't seem happy today. What's the problem? What do you understand by binding? If we're saying the contract is binding, what does that mean? Judith. It means the parties are obliged to perform the functions under the contract, right? Binding, it means it's legally enforceable, right? Clear? Miss Maya, are we together? A contract is binding, it means it's legally enforceable. Yeah? To say a contract is binding, do you understand what it means? We've been talking about this quite often. Binding, do you understand? It's legally binding. It's legally enforceable. You are legally obliged to perform the terms and conditions of a contract. When you say lawsuit or I'm going to sue you, what does that mean? I'm going to sue you for breach of contract. Patience, how do you understand by I'm going to sue you for breach of contract?
When one tends to suffer from like a loss in business.
Good. Innocent.
Can you come again?
If I say I'm going to sue you for breach of contract, how do you understand that as somebody who has studied law of contract? Yes, Mpenya? Taking somebody to court for what? Suing is taking somebody to court. Yeah, for what? Breach of contract. What is that? What does that mean? For not fulfilling their obligations under a contract. Okay? Clear? Any questions? When you talk about jurisdiction, what do you mean by jurisdiction? So jurisdiction is, it means several things. President Mnangagwa has jurisdiction over Zimbabwe. President Chakwera has jurisdiction over Malawi. Simple, yeah? The jurisdiction of President Chakwera is Malawi. The jurisdiction of President Mnangagwa is Zimbabwe. The jurisdiction of Lilongwe University does not extend to Magu. So jurisdiction means several things. It can mean a place, area. It can also mean power. I do not have jurisdiction over Mpenya in a house because he's an adult. I have jurisdiction over Takuzwa in class because I'm the professor. Clear? Do you understand? We can use the term jurisdiction interchangeably. The High Court of Zimbabwe does not have jurisdiction over a contract made in Malawi because it is the laws of Malawi that govern that contract. We're using the term jurisdiction interchangeably. Chisomo, you're able to understand, right? Precious, clear? Jurisdiction, okay. So now I'll give you time, if you don't have questions, to read the two cases I sent. Next time you ask for something, ask a particular person on the group to say, may the president send me a document? I want an outline.
Sorry.
No, but I mean, that's why we're not receiving a response. You have the agreements, you have the cases. Who does not have the case? Who does not have the case? We all have cases, yeah? So I suggest you start with the shorter one. The shorter one has 5 pages. The far distributors one has 5 pages. Then the other one has 19 pages. How much time do you need to read that? Linda? Hmm? 20 minutes for the shorter one. 20 minutes. The shorter one is 5 pages, so 10 minutes. Then the other one is 19 pages. By the time you know how to read a case, I'll give you another 20 minutes. Then we discuss. Clear? I want the first person to finish reading the first case to signal to me that they finished. Who has finished the first case? First case? Who has started reading the second case? Who has started reading the first case? Which case are you reading?
The second one.
Hmm?
All the 5 pages. So,
You still haven't finished it.
no, confused.
On which page are you?
On the 3rd page, so.
Who has finished reading the first case? Hands up. Who else? Okay, good. Are you on the second case? Mpenya, where are you? On which page? Jean, where are you?
I finished the 4 pages, and now I'm reading about my answer. I don't know which page I'm on because it's not showing me, but I'm somewhere. But I don't have words.
All right. In the interest of time, let us. This task you're supposed to do it by yourself. So I just gave you time to read. I see you guys are slow readers. So let's first discuss the far distributors case. Far distributors case. Who is able to outline the facts? I think now, Linda, you can describe it better. Give us the facts of the case. Number one, who are the parties in that case? The parties, I mean, who is the claimant, who is the defendant? Chisomo? Judith, we're talking about the far distributors case. Who is the claimant? The claimant is somebody who sues. The defendant is somebody who is sued. Edwin, who is far distributors there? The claimant or the defendant? Tulinde? Claimant, who? Okay, and MPC? Mpenya? They're the defendants. Okay, so what are the facts of the case? What are the facts of the case? Linda? You are referring to what?
I will explain the second case.
Okay. What about the first case, Ivy? What are the facts? Yes, Nigel. Hey, you gotta cut down on the yeah?
In a nutshell, the case is.
I like that, in a nutshell, yeah? What does a nutshell mean? In a nutshell? In brief, yeah? Well done, Nigel. Yes?
The case is all about Mr. Matthews Malata in Malawi Housing Corporation.
Now, we're discussing the excellent, you will discuss that later, but we wanted to start with a simpler one, the far distributors one. Far distributors, the 5-page one. Everybody else must have read the 5-page one, yeah? Patrick, did you read the far distributors case?
Yes.
Yeah? So what are the facts of that case? You wanted to discuss the second case, which is, sit properly. Yeah? Which one? Yes. So what are the facts? Who is the claimant or plaintiff in that case? Who's that? Who's that? Louder? Claimant. Who is a claimant in that case? Good. And who is a defendant? Chisomo? NPC, okay. So, Precious, what are the facts of the far distributors and MPC? What are the facts? You know, we understand by facts, yeah? What happened? Why did far distributors go to court? It's a simple case, 5 pages, and the facts are mainly on page 1. Yes, Mona?
The first question
Uh-huh.
that the MPC or the
Good. So the claimant is far stationary. Is it far distributors or far stationary? They sued MPC, Malawi Post Corporation. They claimed that they got an LPO, local purchase order, from MPC through their agent. And because of that LPC, they went further to get the books published by the Lihuni Press or one of the publishers. Yeah? So they sued for performance, that specific performance, that MPC should receive those books because they ordered them. So MPC said, no, we did not order. Who placed the order? They said, this particular person. So he said, oh, this particular person is not our agent. And this particular person was not authorized by us, so he's not our agent. We did not order. If we want to order or place an order of that magnitude, we usually write what we call request for quotation, and that was not written. Okay, if you're saying we order, what did we order? How many books? What sort of font? In what paper? You know? So they failed to prove that. So I said, now I think there was no contract at all. So there was no contract, right? Why was there no contract? Why did Justice Dr. Ntambo find that there was no contract? Edwin? Louder?
I think because there was no proof.
Yeah, first, capacity. Capacity of the agent. Agent did not have capacity, did not have authorization, yeah? Secondly, yes? Documents. So there was no offer, there was no acceptance. So there was no contract. The guy who they presumed to have been in contract, entered into a contract with them, did not have the capacity, was not competent. Issues of forgery, illegality, you know, mutuality. MPC had no relationship with far stationary. Do you understand how now contracts work in practice? So what I want you to do as students of business law, when you're talking about offer and acceptance or agency or any issue relating to elements of contract, if you cite the case of far distributors and MPC to back up your position, then that means you score more points. That's how lawyers survive. To back up what you're saying with either a section of the law, of the statutes that you read the other day, or a case authority. That's the whole idea of being a lawyer. Speak with authority. So for example, there was no agency as decided in the case of far stationers against Malawi Post Communication Corporation, where an agent was not given authority to enter into a contract. The court decided that there was no contract and could not enforce the contract. So that's how we answer a legal problem. Clear? The way we write a case is we write a case and underline the name of the case and underline to show that it's a case. We always underline a case. Clear? I will give you more examples in due course. Yeah? So that's a case of far stationers against MPC. Patience, what did you get from the case? Anything that you remember from the case? Judith, anything that you remember from the case? Judith, anything that you remember? Yakosa? Anything that you remember from the case that we just discussed that you want to add? I can't hear. I can't hear. I can't understand. Louder. You need to have confidence. Remember, class participation is also part of the grading, right? So don't think that I'm mean on you if you can't say, if you're saying something that I can't understand. How do I grade you? Gertrude, you've been so quiet. Are those is that your group? Is that your gang? You always sit together. Eh? Do you have a partnership? Do you have a company? All right. Clear? Let's migrate now to the second case. You say and then you add whatever is going to be omitted. Okay, Linda, isn't that the agreement that we made? Louder?
I said I will explain in 5 stationers.
Is that so? Tell us about fast stationers.
Okay, what I've read is that an agent is a person who has authority or capacity to act on behalf of another, while that other in a contractual relationship with a third party.
Good. So if I ask an exam question to say who is an agent, would that be difficult to answer? No, I'm just asking. You don't want me to review the exam questions? I shouldn't.
Yeah, you should.
I shouldn't. Yeah, so who is an agent? Is that going to be difficult to answer? Jane? Just because you stay in areas in 6 miles, then the question should be difficult. Oh, that's 6 miles. She's 49. You ran away from class the other day. I thought you... Yes. You continue. Yes, Linda?
So the evidence shows that Mr. Jibaru had no actual authority to place an order on behalf of the defendant. His authority only extended to receipt of goods ordered, not ordering.
No, I don't want to read. I want you to regurgitate. Okay, leave your phone. Leave your phone on the desk. Who is an agent?
An agent is a person who has authority or capacity to act on behalf of another,
Who is the principal? Yes.
and find
Hmm?
who has the capacity to another, and bind the other.
Good. Well done. So let's go to the second case. Nigel, did I see a hand up from you, Patience? Nigel?
Second case is between Matthews Malata and Malawi Housing Corporation. Briefly, the case talks about Mr. Malata purchasing failing to renew the house lease, whereby there were dates that were set for him in order to finish the payment, and he couldn't make it up till the Malawi Housing Corporation seized back the property.
Yeah. So what are the issues in that case with regards to elements of a contract? What did you get so far? Before we pose that question, who is the claimant in that case? Precious? Who is the defendant in that case? Patrick? Good. So what are the elements of the contract in that particular case? Yes? Pena?
The contract was seized.
Now, what are the elements that you see in that case? Yes, Edwin? You're not Edwin, yeah?
Innocent.
Innocent, yes.
Oh,
Offer, yes. Innocent.
this is Edwin.
Edwin, you're innocent, yes. Edwin.
Acceptance.
Acceptance is also in there, yeah. What else? What else do you see in that case? Yes, yes, a good breach, yes, but you need to learn how to raise your hand. Yeah, what else? What else? Yeah. Yes, Precious? Competence. Nah, competence is not there. Yes? Variation, yes. Well done, well done, well done. Excellent, excellent, excellent. Okay, good. So,
Sir, what about condition?
what?
Condition.
Commission.
Conditions.
Conditions. Yes, yes, it's a conditional type of contract. It's a conditional contract. Well done. Well done, Edwin, right? Good. Yes, Mona. Consideration. Yes, 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 yes. Good, good, good. Excellent, excellent, excellent. So you enjoyed reading the case, yeah? What else did you see, Patience? Well, what did you see? The pages that you covered. Who is a plaintiff in that case? Who is a plaintiff or claimant in that case? Defendant? Who is a defendant? Miss Ngulue, who is a defendant? When you talk about defendant, who is a defendant? Who is a defendant, Ivan? Gertrude, who is a defendant?
The one who's defending the case.
The one who's been sued. Well done. Lorraine, who is the plaintiff or claimant?
The one who's sued.
The one who is suing. Patience, who is a defendant? Ivy, who is a defendant?
The one who's sued.
Defendant. Yakoa, defendant. Louder. Defendant, okay. Who is a claimant? Who sues, okay. Good. So, how did the court decide the case of Mahata against Malawi Housing Corporation? How did the court decide? Can somebody read page 22 and tell me? Just page 22. What was the conclusion? Nigel, did you finish reading it? Okay, so in short, the court found out that Mr. Mahata did not comply with the terms of the agreement, because the agreement was on condition that he pays the full amount. It was an express agreement, right? It was conditional agreement, that the agreement will be there in the event that he pays the full amount by such a date, which he failed to pay, not full amount. And the contract also said that if he does not pay by such a date, then the contract falls off. So he did not do that. So the contract was repudiated. By not complying with the terms of the contract, he repudiated the terms of the contract. I would ask you to read that case, because Judge Mangulu is talking about several other issues. He's talking about equity, and he's even explaining what equity is. He's talking about a lien. So read that case in full at your own time. Is that case clear? So unfortunately, Mr. Mahata lost a house here in Area 15, but he had paid something. He lost the case, and he also lost the house. Bad case, yeah? Any questions? Any questions? All right. So we've covered a law of contract. You need to read the document that I sent you with regards to law of contract. You also need to read those two cases because the questions will come from those two cases. Clear? Lorraine, is that too difficult for you to pass an exam? If I would give you an exam tomorrow, would you pass a law of contract exam?
Yes.
Who is saying yes? Yeah. Edwin, would you pass?
Yeah.
Innocent, would you pass?
Yes.
Okay. Ivy? By, on a scale of 1 to 10, what would be your grade? Sit upright. What would be your grade?
8.
8. Oh, wow. Excellent. Excellent. What's the difference between an offer and acceptance? Let's see if you can. Okay, maybe that's a 2 that you're gonna fail. Yeah. Let's look at the 8. Let's look at the 8. What is the difference between a contract and an agreement? Now you are on 6. 6 out of 10. Let's look at the 6 that is remaining. What are the elements of a contract? Name any 5 elements of a contract. Now you are on 4. Okay, please make sure you catch up, yeah? So next week I'm not going to be around. I'm going to teach elsewhere, but I'll come the other week, the week beginning 2021. So that week we'll also have 2 classes because I will not be, okay, so today we've had 2 classes because next week I'm not around. But when I come on the 2021, I think on the 22nd, we'll also have 4 hours because I won't be available week beginning 27, 28, thereabouts. So get used to this kind of teaching. Get used to this kind of teaching. But what I want you to do is to read in advance. So now, this is the deal. Next week, we've done law of contract. Now we start company law. So I want you to read the book by my friend Alan Mohammed. Alan Mohammed, I want you to read from page 34. To 55. Then you should also read page 57 to 80. Yeah? So I want you to read this, page 34. Basically page 34 to page 80. Okay, let's just do this. Let's read 34 to page. Let's read page 34 to page 96. 34 to 96. If you can't understand, just skim through, yeah? But at least read. Easy. Why is it difficult to read? Huh? I can't understand one person at a time? Yes?
Reading is not a problem, but then understanding.
Understanding. Yeah, that's why now you're reading in advance, yeah? So I'll come to explain, to help you understand. You get a point? You're reading in advance to make it easy for me to explain to you, so that you don't look dumb when I'm posing questions. Yeah, so also read the Chilumba book on what we say Introduction to Company Law. All these books you have, yeah? Introduction to Company Law. Read from page 12 to page 61. And also from page 92 to page 99. So if you read, I would suggest it will be easier for you to start reading Chilumba, because it's easier, it's shorter and more straightforward. If you read Chilumba from, I said page 12, yeah? I said page 12 to 48, right?
61.
I said 61. Okay, 61, good. Then what else? Yeah, Chirumba. Yeah, start with Chirumba, read that, and then go to Muhome. Chirumba is more straightforward. So when we're reading Muhome, it will be easier. So what I want you to understand, just to give you, how much time do you have? Okay. So what I want you to understand is that what is a company? A company is a legal person, right? Because you create a separate legal entity. What are the types of companies? Private company, public company. Private company limited by guarantee. Public company, or company and limited by shares. All those issues. Then how do we form a company? You need to have shareholders who are also called members. Then you need to have directors. Who are directors? Directors are the ones managing the company. What do you do to form a company? You need articles of association and memorandum of association. What are these? These are the documents that would put everything, like it's a constitution of the company. It governs how the company is going to be run. Where do you register companies? At the office of the Registrar General. Yeah, so what happens if if a company has wronged somebody? Because it's a separate legal entity, then the company will be liable. What happens? Who is going to be liable? The shareholders or the directors? So it is the directors. What if the directors are not there? You go to the shareholders. So those are the issues. Interesting, isn't it? Yeah, easy. Company law. So I'll ask you, what do you mean by penetrating the veil? Penetrating the veil. So penetrating the veil is a company is here, yeah? A company is, you don't see anyone, it's just a company, right? So if you want to sue ShopRite, who are you going to sue ShopRite? Are you going to sue the building? Are you going to sue the manager who's been employed by ShopRite? Who are you going to sue? Hands up. You are next time press ups. Okay. Yeah. Who are you going to sue? Yes, Precious. You sue because now the company is a separate legal entity. So you sue the directors of that company. So you sue Shoprite Company Limited. Who's going to be responsible? The directors, not the employees. The employees are just workers, right? You sue the directors of that company, the ones who have been mandated by the law to run the company. Now, what if the directors are not there? So the idea of suing the directors is what we call penetrating the veil of the company. The idea of saying who is behind the company. You penetrate the veil of incorporation. Questions? Do you feel satisfied that you're learning something? You're learning, can you call yourself a business lawyer? Hmm?
Prospective business.
Yeah? Can you assist somebody to open a company?
No.
Can you assist somebody to enter into a contract? Yeah? What do you need for somebody to enter into a contract? Yes? You need a contract, yeah? Should it be written or oral? But it can also be oral, right? Okay. No, thank you so much for your patience. So we meet again. Say again? Attendance, they didn't give me today. Eh? Class president, can you go and look for the guy?